Okay, you're Floyd Torin. And this is cause numbers 25 DCCR 0974 and 25 DCCR 1152. Mr. Torin was previously in court, entered pleas of guilty to attempt to commit theft of property. It was enhanced to a second degree because of priors, and then evading arrest or detention with the vehicle, also enhanced to a second degree. I've received the pre-sentence report, and the agreement was for a cap of 20 years. It looks like it probably could have been habitual, but you guys pled it to just a straight second degree with an open plea to the second, correct?
Yes, ma'am.
And I've received the pre-sentence report as well as some documents that Mr. Radford has sent in with regard to Mr. Torin's mental health, as well as some physical issues, and one letter as well of support. Have you both had an opportunity to review all of that?
Yes, ma'am. Yes, Judge.
Are there any additions or corrections to that pre-sentence report?
Just the things that I submitted, Judge.
Okay, Mr. Radford, you may proceed.
Right here, the defense is doing exactly what defense attorneys are supposed to do during sentencing, humanizing the defendant. Notice the strategy. Health problems, mental health treatment, family support, and age are all being presented as mitigating factors. In other words, the defense wants the judge to see more than just a criminal record. But there's a huge obstacle standing in the way here: repeat offender fatigue. Judges hear promises of change all the time, especially in cases involving addiction. The problem is that courts tend to focus heavily on patterns, not intentions. And once someone racks up this many felony convictions, every new offense becomes harder to explain away as a mistake or temporary lapse in judgment. Question for you guys watching: should addiction and mental health reduce punishment in repeat offender cases, or does public safety eventually outweigh sympathy?
Judge, Mr. Torin has an extensive criminal history. However, as he has gotten older, he has had some health issues. He has vision problems. He has been seen and treated at Spindletop MHMR for some mental health issues. He has a very supportive family who is here today, and I'd ask that the court take that into consideration in determining his sentence.
What is the status of parole?
No, we're waiting on the way. Okay.
Mr. Smith?
Judge, his extensive criminal history going all the way back to his juvenile years tends to show more about what he is and what he does than anything else. He's been given probation. He wasn't able to complete that. He has been sentenced to multiple long sentences in prison, and that seems to be the only thing that has kept him from committing new crimes in society, was the fact that he was incarcerated.
That statement from the prosecutor is absolutely devastating. The only thing stopping him from committing crimes was incarceration. In sentencing hearings, prosecutors often try to prove future risk, and this is one of the strongest arguments they can make. They're basically telling the judge, every time this defendant is free, new crimes happen. And honestly, the timeline here is brutal. He gets out in August of 2023, and less than 2 years later, he's already back facing 2 more felony charges. That destroys almost any argument that prior prison sentences worked as rehabilitation. Also, pay attention to the plea agreement here. The prosecution actually gave him a break by not pursuing habitual offender enhancements, which could have pushed punishment even higher. So while 20 years sounds massive, the court may actually view this as leniency considering the defendant's history.
I don't feel like probation is appropriate. We would ask for, we have given him consideration by coming off of the habitual and capped this at 20 years. So we would ask for a TDC sentence in the high range on this.
Mr. Torin, in 2019, you received a 15-year sentence. So you were only I don't know how long it doesn't show me when you got out or how long you were in on that, but obviously. So you got out in 2023, and less than 2 years later, you've got 2 more felonies. which add up to your 11th and 12th felony offense.
This is the moment where the judge stops talking like a neutral referee and starts speaking directly about accountability. And you can hear the frustration building. Judges tend to have very little patience when they believe someone has repeatedly been given opportunities for treatment, probation, parole, or reduced sentencing, only to return to criminal behavior again and again. What really stands out here is the judge's comment that his only clean periods occurred while incarcerated. That observation cuts directly against rehabilitation arguments because it suggests external control, not personal change, is the only thing keeping the behavior in check. It's also important to understand that parole violations carry enormous weight in sentencing. Committing new felonies while already under supervision tells the court prior interventions failed completely.
And I understand the issues with PCP. It looks to me like that's more of an issue than anything else. I understand there's some mental health issues, but you as a grown man have had every opportunity to get help and try to get in TDC, out of TDC, to live your life outside of prison, and you've chosen not to do that. Your only time clean is when you're in custody. That's what you told the person doing that substance abuse assessment. I don't know. I just think it's I appreciate your family being here, and I appreciate the support, and I appreciate this letter, but it's all ridiculous when you look at your criminal history and the fact that you're on parole and you commit 2 more offenses and you're still using drugs, and it's not like you're a young kid. You know what you need to do to get the help you need to get. And you've made a conscious decision not to do that. So at this time, in cause number 25 DCCR 0794, and
this is where the case becomes far more serious than simple theft charges. The judge is now painting the full picture of the evading arrest incident, near collisions, interstate intersections, crashing through a fence, continuing to flee after multiple crashes. This wasn't reckless driving. This was potentially deadly conduct. In sentencing, judges often focus heavily on danger to the public, and this type of behavior immediately raises concerns about innocent people being hurt or killed. What's fascinating is that the judge almost sounds personally alarmed recounting the details. That usually means the court views the conduct as far beyond ordinary criminal behavior. A lot of viewers may wonder why evading charges can carry such severe penalties in Texas. This is exactly why. Police chases can turn catastrophic in seconds, and courts often sentence aggressively to discourage them.
this evading was crazy. I mean, you could have killed people. You got used, I think it was twice you almost struck intersection of Interstate 10 and 7th Street, almost struck another vehicle. And then again at 7th Street and Dollinger, you almost struck another vehicle. You crashed through a fence. Then you continued to flee after you crashed through a fence and crashed again and finally came to arrest. I mean, it's not like you just kind of sort of evaded. This is, your behavior is just a danger to everybody here in Jefferson County. So that being said, 25 DCCR 0794, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of an attempt to commit theft of property, find that prior conviction true, or the prior convictions true in that case, sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. And cause number 25 DCCR 1152, find also sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true, sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Correction. You will receive credit on each of these sentences for any time that you've been in custody that the law gives you the right to receive.
Now here's a legal detail many viewers misunderstand. The judge sentenced him to 20 years on both charges, but because the sentences run concurrently, he serves them at the same time rather than back-to-back. That means this is effectively a 20-year sentence overall, not 40 years. And honestly, that's a major distinction. If these sentences had run consecutively, the outcome would have been dramatically harsher. Also notice how quickly the hearing shifts into procedural language once sentencing is announced. The court is now locking down legal formalities: appeal waivers, firearm restrictions, custody credit, and acknowledgement of rights. These details may sound routine, but they're critical because they protect the conviction from being challenged later. Once those procedural boxes are checked, the sentence becomes much harder to overturn on appeal.
I'm handing you, and they will run concurrently, which means together at the same time. I've handed you the trial court certification that shows these were agreements. I followed. You've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. Read that. You should already understand it. But if you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Radford. All right, you can go back with the bailiff. Yes, sir.
In the end, this sentencing hearing came down to one central issue: rehabilitation versus public safety. The defense presented mental health struggles, addiction, physical decline, and family support as reasons for mercy. But the prosecution, and ultimately the judge, focused on the defendant's long criminal history, repeated parole failures, and increasingly dangerous behavior. The final result: 2 concurrent 20-year prison sentences for attempted theft and felony evading arrest with a vehicle. The court clearly concluded that prior interventions, probation opportunities, and prison terms had failed to stop the cycle. And when judges believe someone poses an ongoing danger to the public, punishment almost always becomes the priority over rehabilitation. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.